A very good morning and welcome to another episode of Law and Order, where we discuss the current issues and answers for them in a legal scope. So ladies and gentlemen, as we all concentrate on certain topics, today also we have a wonderful topic and a timely important topic to discuss with you all. And to do the honors with us, we do have Senior Counsel Attorney at Law, Mr. Ian Fernandez. Thank you very much for joining us with our program. And today we are going to discuss about the electronic media, one of the most important and controversial topics when it comes to the present context. And there are most interesting things and cases that we have to discuss. So first of all, can you just let us know, is a photograph, how does it come into play?
The photograph is admissible in the court proceedings. As you will recall, the case of the Queen versus Abu Bakr, reported in 54 new law reports at page 566, I believe, where contemporaneous recordings, even at that time, that's somewhere in 1954, from there on was allowed to be admissible in court. The word admissible is, in court it is allowed as evidence. That is what the meaning of admissibility means. So as far back as 1954, as I said, set out in the 54 new law report at page 566, in the Queen versus Abu Bakr's case, they allowed contemporaneous recordings. Then subsequently, in 1955 new law reports at page 511, in the S.A. Vikramasinghe's case, this was recognized, and the development of the law sought that in section 3 on the Electronics Evidence Act, the special provisions of the Evidence Act which embodies electronic evidence, they allowed contemporaneous recordings such as photographs and whatever other recorded messages to be admissible in court.
Admissible, then simply a photograph, and when it comes to contemporary recordings, they are admissible in courts. So you mentioned two cases pertaining to those things as well. So apart from photographs, videos and other things are admissible.
Yes. The Indian law, the Indian Evidence Act in 1872 was repealed, or when I say the new sections were brought in, section 65A and 65B, to allow evidence of that nature to be brought in the Indian Act. And so soon thereafter, Sri Lanka, we copied it in the Act number 1995, section Act number 14, where the Electronic Evidence Act came into place and allowed the special provisions of the Evidence Ordinance, as it's called, to allow you to bring those recordings into court.
Right, and in foreign countries and Sri Lanka also, photographs and contemporary recordings, they are admissible in courts and they are currently being used in court proceedings.
Yes. For example, if you have a photograph of a person in a very compromising situation with another, say husband and wife couple, or unmarried couple in a very compromising position, supposedly that document as a photograph can be produced in court, so far as you can produce the negative of that photograph.
Right.
The negative has got to be produced for the photograph to be produced. But in today's context, we see that negatives are now done away with and it's all electronic, and so you have to produce that evidence, the photograph or the electronic message, via giving an affidavit to court as to who recorded it and what instrument recorded it.
Right.
What is the model of the instrument, the make of the instrument. You have to swear affidavit under section 4, 5 and 6 of the Evidence Ordinance Special Provisions Act, which encompasses electronic evidence into our law.
Right, that means the instrument is being recorded is also takes a prominent thing.
Prominent.
Right. Okay. So little bit moving along with the topic, but the fact that you said, when in that type of a situation, can the other party blackmail or harass some other party depending on that photograph?
On the photograph will give you, say for examples, if you take a nude photograph of a couple who are not married and it's used to use it as ransom, that can show that there is an intimate closeness to them, But on the grounds of adultery, if you take it, where you had to prove beyond reasonable doubt, then you will fall short of it, because the case law set out, if I can recall, in 55 New Law Report at page 410, and the recent judgments, adultery should be proved beyond reasonable doubt.
Yes. We also discussed in divorce in the previous episodes as well.
So if you have a photograph of two nude people together, you could come into the conclusion that there is corroborative evidence, but it doesn't come into the strict rule of 100% proof.
Right.
One can take a defense saying that they went for a nude swim, though it might be not be prohibited in Sri Lanka. They don't have to say that they committed adultery, but to be in a nude photograph together may give rise to the thinking to corroborate the evidence of grounds of adultery.
Adultery, right. So that is something very important, and is it a loophole there?
Yeah, it is a loophole to say that if you are trying to produce a photograph of that nature, there will be a lot of defense taken when you are producing it that you can't produce it, but you might be able to get past that by saying that this is a necessary fact or relevant fact to the fact in issue, which are legal terminology in the evidence ordinance, and grant permission if you have construed to the correct provisions of the Evidence Ordinance Special Provisions Act, section 4, 5 and 6, wherein you have sworn an affidavit, the person who has taken the photograph, and the instrument is available for recognition, and you have followed the 45 days pre-trial notice that is necessary to be given. All those legal provisions are embodied in the Act. If you have followed the correct procedure, certainly you can lead the evidence.
So
however, in cross-examination, if you have not followed that procedure, you may be able to allowed to mark that document in cross-examination to impeach the credibility of the witness, because the Evidence Ordinance Special Provisions Act says when you are moving to mark it for the trial. So in cross-examination anything can arise, and upon the reason of that fact you can bring this evidence to court, maybe even if it is not listed, or whether you have not followed the section 4, 5 and 6 of the evidence ordinance.
Evidence ordinance, right. That's an important area.
That's a loophole.
Loophole, right. So we're discussing about the loopholes and current trends and certain issues in applicability, and you have that practice more than 3 decades. And simply moving to another thing, sir, suppose that picture is uploaded on social media, Facebook.
Yes.
Is that the same applicability?
Justice Chittaseri, in a commercial oriented case where the Commercial High Court in case number 181/2007 gave judgment that if you send SMS from A to B, that B could produce that in court. But if you send a SMS from A to B and B has passed it on to C, then of course you will not be able to produce it in court. So once you have uploaded such a message, as I mentioned the A to B example, that could be used, if it's a SMS, that could be used in court.
Any media.
So you can construe that a little larger or extension of that principle to say if a SMS message has gone, even a WhatsApp message and Facebook message is allowed under that particular 181/2007 judgment, but that's the extension of the law which is still to be probed into. But there is an area that you can portray into and get the judge to give you a finding whether you are admissible or not placed on that judgment.
Right. So depending on that thing, using social media, we have that right to speech. And how does it contrast with defamation?
Now in the US government, the Constitution, one of the first things that they recognize is the right to speech, and that the first amendment or whatever came regarding your fundamental rights on speech, how much it can be curtailed. Even in Sri Lanka, one of the fundamental rights is right to speech in the Constitution set out in the articles, but it is curbed on public interest, public security and so many other matters. So your right to speech now via SMS and via this Facebook formation, via new Facebook and different other platforms like Telegram, you can do. So long as you are not harming the reputation of the other person. If you harm the reputation of the other person, in a defamation suit, you have to proof of publication must be there.
Right.
So the proof of publication you can only prove to how many people that message was sent. So if you can come into those areas that there is a defamatory act publicized which will cause you some damage, you have a clear case for defamation.
Defamation, right. So with that, sir, I think our viewers might be enthusiastic to learn about the grounds for an SMS.
Yes. So the grounds for the SMS must be, first, if you are going for a lawsuit, must be of a malicious nature. Now I will quote the judgment wherein one Answorth, who was brought in a defamation case
That Elon Musk.
against Elon Musk.
Yes.
I'm sorry, I can't give the reference because my junior who did this reference has not provided me with the reference. But however, a Herculean task has been done by her to get me this case laws,
Right.
which you could search on the internet. And may you repeat that judgment again? The name is
Elon Musk versus
Answorth. So in that judgment, it was set out that Answorth was a good diver. And he had dived into a cave during summertime where there was a flood and rescued 12 boys.
Right.
And Elon Musk, who is one of the founder members of Telstar, had given a comment on Twitter saying that Answorth was a pedo boy, basically telling he's a pedophile. And then Answorth sued back the Telstar owner, the founder, for damages. In the court, it was held in the Californian courts that the word pedo boy was not enough of a connotation to damage the reputation of Answorth. So his action was not allowed. So you have to prove your case. It would be very clear that there was defamation caused.
Right.
In the second instance, if I can recall, the case cited in the action where one lady filed action against another lady, the lady first being an owner of a tax consultancy company. She filed action against another lady that she was defamed by her, wherein she said that after so many years, the first lady was sued for damages because she has said that the second lady's son died of an accident 40 years ago, and due to that it was not reckless driving, it was other matters, drunken driving and so many other things that caused the death. So in this case of Jacqueline Hammond, implied that a previous business rival, Diane Dial, has made this accusation. Diane sued back Jacqueline Hammond for the wrong that she had said over the particular incident. And in that case, she proved that it was done in a way that should not be committed. However, they settled the case at $500,000 because proving such an instance is of great magnitude. So it was better for them to have sorted the matter out by settlement.
Right. Few interesting judgments related to our discussion, and one thing that we can emphasize here, any mental discomfort to some other party. How can you elaborate that on it?
In the recent judgment set out in 2016, Entertainment Law Reports at page 12.
Subrahino versus
Subrahino versus Impresa Publishing. That is, I have given you the reference now, 2016. EMLR 12. Entertainment Law. It has been decided that if you make a WhatsApp message, that is, a WhatsApp message is a message from one person to another person. If you make a WhatsApp message which is so derogatory so inhuman, which causes mental damage to the other party, the party receiving that message can file action for damages against the person who sent it. So that's a very important matter, because if you keep sending very derogative WhatsApp messages to another party time on and bringing that person's mental capacity down, that person has a very good case for damages. For examples, if that person suffered immense mental pain of mind, had to go and see a psychiatric doctor and take medicine because of those messages sent, that particular aggrieved party has a good case against the sender of that WhatsApp message for the derogative statements made.
Right.
So that same yardstick could be used even to Facebook and other social medias, but this is also a decided case in 2016.
Right.
And it says very clearly that you cannot take the defense that it's done by a mistake or outburst of rage that you have done it. So you have to be very careful when you are sending any WhatsApp message which can be derogative to the other party, because he has a right to sue you for damages. Like hatred speech and things like that.
Right. So concluding that thing, so like Facebook, WhatsApp and other social media platforms, any messaging app, so they comes under defamation if he did something.
Yes, to come under defamation is difficult unless there is proof of publication. This case which distinguishes from the proof of publication is, this case sets out, it's sent from A to B so as to cause mental pain of mind. So there you would see there is no publication. But it's an act done to cause you mental pain of mind. So that is why they had given damages in that case. But in all other instances, you have to have a very good proof of publication. Especially if it's Facebook media, there's a lot of publication. WhatsApp may be only a group which is of a defamatory character, you have a right to sue.
Right. So what about the tweet messages, as Elon Musk and everything, they do apply the same thing when it is published. So a message published there, won't it be a publication, sir?
Yes, it is to an extent a publication, but it is not a public publication. In that Elon Musk case, it was a public publication because so many people were aware of that.
Right. That means depending on the followers, the way that the message reached.
Right. But the judges in that construed that though he is called a pedio boy, the word pedio boy in 2016 or before that, or whenever the case came into existence, was not much of a thing to be considered. As of now, it might be a different situation. If you are called pedio boy, you might be having a good case for damages.
So in any case, any situation for a defamation or insulting or any harm that is caused to some other party, we need to have some intention. So how intention is proved in this scenario?
The mens rea, which is the Latin word for intention, for any criminal act to take place, that there should be an intention to do that. You cannot unintentionally do a crime. Then it will not be a crime.
Right.
So there has to be some performance before the act, that there will be facts to construe that this was the idea, that so many messages were sent to this person to mentally harm him. There was some litigation going on between him and the person who sent that message.
Right.
Or there is some animosity between that person who sent the message to the receiver. Or the person who sent the message was jealous of the other person, and why the jealousy was, you could prove, and that is why that type of message was sent. And it has to be continuous. You can't say you have sent the message once or twice and ask for damages. It has to be continuous so as to mentally make him fall, mentally derail him and make that person fall. Then that person has a right to sue.
Right, so that means like one text message, second, third, you can't go for any damages, but that should be continuous, and that mental element must be proved, and it should be proved, and it must be available with some sort of evidence with regard to the continuity and the way that insults and the other background information as well. So simply, when it comes to WhatsApp, Facebook, those are the most common things that the people use. So is there any difference between WhatsApp and Facebook in a legal way?
Charita, coming before you come to that, I'll answer you on that. I did a similar case which I saw in court happening in the outskirts of Colombo in a district court, wherein a married person was harassed by his secretary out of very many messages sent to him and his family, and that he took on his secretary in court for a damages case, and in that damages case he was able to construe and show all the messages that she had sent, which are very alarming and damaging to his character. And the court granted an enjoining order, or what do you call an order in legal parlance, stopping that lady from sending such a message to his family or to him. Now you see, there is no publication there. The publication is only between his family and him. Right? Then the second time she still contemplated and sent that message after she was warned by him and by the court order not to send such messages. Then she was brought before the court for contempt of court. And she settled the case by stating that she will never ever harm the particular gentleman or his family by that type of message, whether it's by Facebook, by Messenger, by Texas or any other type. And she gave an undertaking, and if she does that, the penal clause was that she would have to fork out 50 million as damages to the plaintiff for what she has done in the past. So it can be a very hard situation that if you go on pounding on some person with SMSs and Facebook and things of that nature, he can turn back and send you a warning that if you do this any further, I will be going to court and collecting damages from you. Your question whether is WhatsApp and Facebook the publication, there is more publication, I believe, in Facebook than in WhatsApp.
People must be very careful when using Facebook.
Very, very careful. Not only trying to portray what you have done, you must portray exactly what you have done. If you portray something more than what you have done, you can be told that you are not portraying the correct truth of what you have been doing.
Right. So many important areas, controversial things, and even we simply send a WhatsApp message or Facebook message or a tweet simply saying this is that, but we should be careful, because if we have evidence and if proper legal advices are given, we can proceed even for a court case also. So with that, we are going to wind up today's session, one of the most interesting areas, electronic media. And thank you very much, sir, Senior Counsel Attorney at Law, Mr. Ian Fernando, for taking part with our program Law and Order. Thank you very much once again. And Law and Order, a program where you can get answers for your legal questions and to deal with a successful life, having all the answers sorted out without falling yourself in trouble. Thank you very much, ladies and gentlemen, for joining with us, and stay tuned for more programs in the future as well, and have a pleasant day.